afternoon and welcome to our webinar today on dismissals. Thank you for joining us. We have muted all our attendees on the webinar today. If you have a question, could you please use the chat box in your control panel displayed on your screen, and we will endeavour to answer as many of those as we can after the session, probably via a follow-up email with the recording of the session, which you will receive in the link email. My name is Lehmann and I'm the MC here today, and I'll also be touching on the tax implications of terminating an employee. We are joined today by David Bates, the Managing Director of Workforce Guardian, our HR partner here at ADP. Welcome, David.
Hello, thanks for having me along. You had to think about where I was from then, didn't you?
I'm fairly certain it's ADP's at most of the time, so yes, thank you, David. We're thrilled to have you here and talking about this exciting subject.
Yeah, it's great to be here. It's certainly a very topical subject, that's for sure.
Oh, absolutely. Well, I'm thinking, seeing as you'll be kicking us off, I'll hand over to you now, David, and we'll go from there.
Thanks very much, Angela, and thanks again for having us along today. It's a real pleasure and a privilege to be here with our partners at ADP to talk about what is obviously a very, very sometimes touchy subject, because everyone, I suppose, at some point in their life is either made redundant, or they are dismissed, or they have to deal with the dismissal themselves. Yeah. So it's something that will touch upon us, most of us anyway, in our working lives. But the difficulty that we've got is that, of course, here in Australia, we have such complex employment laws that if we don't know how to go about dismissing someone unlawfully, we can end up in all kinds of trouble. Yep. So what we're going to do in today's webinar is take you through the key things that you need to know about dismissals. And of course, this is part one of a two-part webinar series. We'll do another webinar next week where we pick up some of the remaining topics that we don't cover off today. So if you haven't already registered for that webinar, please make sure you do it, because you'll find it a really useful add-on.
Absolutely.
So today what we're going to be discussing is, first of all, why dismissals matter, and I would suggest that most of you have probably already figured out that dismissals matter, which is why you've joined us today, but let's drill down as to why it is so important that we know how to lawfully dismiss employees. We'll then talk about the applicable legislation and then define some key terms, because we use a lot of different terms, specific legal terms, when we discuss redundancies, dismissals, then the tax implications that you'll speak about, Angela. So I think it's really important that we define some of those key terms right at the outset. Then I'm going to talk about who is actually protected from so-called unfair dismissal under the Fair Work Act, because what we'll discover is that not everyone is in fact entitled to bring an unfair dismissal claim. So we'll talk about who is and who isn't, and in the process we'll bust a couple of myths in there as well. And then we'll go through a step-by-step guide to how you go about lawfully dismissing someone so that you reduce your chances of having a claim lodged against you. And then before I hand back over to you, Angela, I am going to talk about deeds of release, sometimes called deeds of settlement, which are quite often used actually when there are disputes relating to a post-employment claim. And then we'll talk about what to do if you actually have a claim lodged against you. And it's at that point that I'm going to hand back over to Angela to talk about the tax considerations of dismissals. So what do you do from a tax point of view with some of these payments that need to be made when employees are leaving the business? Okay, so let's start off with just a 5-point summary of why knowing about dismissals really does matter. Well, the first thing to note is that the number of unfair dismissal claims, and indeed the number of other types of claims as well relating to employment after it's ended, those types of claims are on the rise. And if we go back, maybe 10 years or so, we in Australia had a few thousand unfair dismissal cases per year. Last year there was around 20,000 unfair dismissal cases, so you can see that there's a considerable increase over the years in the number of people who are bringing a claim after their employment has ended. So if you haven't already been affected by an unfair dismissal claim, chances are if you're running a business or you're in HR within the business, at some point you will deal with them. Next, not only are the number of claims rising, but the claims that are lodged can be costly and very, very time-consuming. Now, I think it's fair to say that most business owners find themselves pretty busy, right? So you're at work early, you're leaving very late at night. Chances are you don't have a lot of free time to be dealing with the unfair dismissal claim that's been lodged against you. And it is going to take up quite a bit of your time, because there's paperwork, there's conciliations, arbitrations, a whole bunch of other stuff as well. And if you do engage a third party to assist you, clearly you're going to be paying for that service. So there is going to be additional cost there. Now, the third point is a very important one. Under the old work choices legislation, that is the legislation prior to the Fair Work Act, under that old legislation, there was a definition of small business, which was any business with 100 or fewer employees. And if your business met that definition, it meant that you were completely excluded from the unfair dismissal laws. So your employees in that business could be dismissed and they couldn't bring an unfair dismissal claim. Well, when the Fair Work Act kicked off in 2009, it changed the definition of small business from 100 or fewer employees to fewer than 15 employees, 15. So a much larger number of businesses suddenly became captured by the unfair dismissal laws. But even more important than that, even if you are a small business under the Fair Work Act, you are in fact still covered by the unfair dismissal laws. It's just that there's a different waiting period, which is called the minimum employment period, and we'll look at that during the webinar today. So indeed, one of the reasons why the number of unfair dismissal cases has risen so dramatically over the last few years is because many, many more businesses are now captured and covered by the unfair dismissal laws. Yeah. Now, when an unfair dismissal case is lodged, it will generally end up at the Fair Work Commission, that's Australia's Employment Relations Tribunal, and the focus of the Commission is on the process and the documentation. So what did the employer actually do and say? What did they provide to the employee during that dismissal process? So we need to make sure that those things are down pat. And of course, the number 5 point here, and really it should be number 1 on your own list, is avoid the Commission at all costs. Anyone who knows me well or has attended any of the other webinars that we've hosted will know that I don't have a lot of confidence, to put it mildly, in the Fair Work Commission, and I really do strongly encourage employers to avoid having to go there at all costs. So if there's a way to do that easily, that is by making sure that your processes are fair and reasonable, and hopefully that will significantly reduce the chances of you ending up in the Commission. Okay, so we've already just mentioned there the Fair Work Commission, which is, again, the Australian Employment Relations Tribunal. Used to be called Fair Work Australia. Before that, used to be called the Industrial Relations Commission. So it's had quite a few different names. But it's really critical to note that if your business operates anywhere in Australia other than WA, and if you're in the private sector, then you are in fact covered by the Fair Work Act of 2009, and that means you are covered by the Fair Work Act's unfair dismissal clauses. Now, if your business is in Western Australia, the Fair Work Act can only apply to you if your business is an incorporated entity. So usually a PTY limited business, but it could be an incorporated partnership or a number of other entities as well. But it has to be incorporated. So for those of you joining us from WA, just keep that in mind. What we'll be discussing today are the laws as they apply to businesses that are covered by the Fair Work Act. Yep. So that's the focus of today's webinar. If you're not sure which legislation applies to you, don't assume. Do get expert advice, because your obligations and responsibilities will be different depending on which law applies.
We always say that to our clients too, David, because a lot of them just do try and assume and sort of ask us to apply something on a blanket sort of assumption, and we always say no, you need to go away and just make sure you are aware of exactly which awards, which legislation apply to all of your employees.
Yeah, absolutely right. And one of the reasons for, I suppose, that confusion is because we've had so much change in Australian employment law over the last few years. I mean, in the last, say, 15 years, we've gone from, legislation before work choices, and then we've gone to work choices. Now we've gone to the Fair Work system. We've got states in Australia that have transferred their industrial relations powers to the Commonwealth. States like New South Wales, Queensland, South Australia, Tasmania. So significant changes. Yeah. It's no wonder that employers are still relying on myths or old rules and, even old ways of doing things. They have all been now effectively taken over by the Fair Work Act. All right, so what do we actually mean by unfair dismissal? This is a term that we sort of throw around. Someone claims to have been unfairly dismissed. What does that actually mean? Well, the Fair Work Act defines unfair dismissal for us, and it says a dismissal will be unfair in 2 distinct situations. The first is if the dismissal itself is harsh, unjust, or unreasonable. Now, it's really important to note that there is an or in between each of those three words. It doesn't have to be harsh and unjust and unreasonable. What most cases turn on in the Commission is whether it was any of those things. So a dismissal could be harsh, but perfectly just and perfectly reasonable, for example, but it's still an unfair dismissal as a result. So harsh, unjust or unreasonable are the key terms to keep in mind. Now, the Act also then goes on to tell employers the types of questions that they need to consider to determine whether or not a dismissal is going to be unfair in the circumstances. In other words, these are factors that would point towards a harsh, unjust or unreasonable dismissal. So the first is, was there a valid reason for the dismissal, and was the employee ever told that reason? The second is, was an opportunity given for the employee to respond to the employer's concerns before the dismissal was confirmed? So let's say you see an employee in your business stealing money directly from your till into their pockets and leaving the business. Well, that's called serious misconduct, as we'll see, and you have the right to dismiss in what's called instant dismissal or summary dismissal. However, before you were to do that, you still have to give the employee an opportunity to explain their conduct before you terminate them. That's made very clear in the Act, and that's a common mistake that employers make. The third is, did the employer unreasonably refuse to allow a support person to be present? Now, this comes up quite a bit, and it's really important to emphasise that there is no obligation on an employer to advise an employee that they can have a support person. It's just that if the employee requests a support person to be present, the employer cannot unreasonably refuse that request. So if there has been no request, there's no issue. But if there has been a request, it has to be considered reasonably. Wow. Now, if a person's being dismissed for any reason other than serious misconduct, that is theft, violence or fraud, most generally, if they're being dismissed for another reason, then really, unless they're a casual, they should have been given at least one final written warning before that. Now, there's no obligation to provide 3 written warnings. That's a myth as well under the Fair Work Act. But if someone is a permanent part-time or permanent full-time employee, they should at least be given a final warning before they're dismissed. And another factor that goes here to harsh, unjust or unreasonable is, did the employer have access to HR expertise? Now, this is one of the, I suppose, few times in the Fair Work Act that special consideration is given for small businesses. And it's recognised that if you're running a small business, chances are you don't have access to the same high-level HR or even legal advice that bigger businesses would have. So they will take that into account, but given that you can go online and find out a huge amount of information about unfair dismissal for free, it's really not going to wash as an excuse that's going to get you off the hook. And in terms of hooks, here's the ultimate one. The final factor is any other matter that the Commission considers is relevant. So we had a famous case a few years ago where an employee was found to have been unfairly dismissed, and the factors that the Commission took into account were things such as the mental health of the employee's wife, the fact that he had never finished high school and had limited life opportunities, the fact that he owed over $70,000 on his mortgage. These were reasons that the Commission said made the dismissal unfair, which is really quite an extraordinary decision, but still it just goes to show that this idea of any other matter being considered, well, it's very broad. So employers really do have a high bar that they have to meet in order to make sure the dismissal is fair.
Oh, my favourite, David.
Redundancy.
Yeah.
Here we are. All right. So we just talked about the fact that there are 2 different ways that a dismissal can be unfair. The first is, as we now know, if it's harsh, unjust or unreasonable. The second is if the redundancy is not genuine. So it might have nothing to do with the dismissal for any other reason. If you decide that you're making someone redundant, but the redundancy itself does not meet the genuineness test as imposed by the Fair Work Act, then a non-genuine redundancy is treated in exactly the same way as an unfair dismissal. In fact, it is a form of unfair dismissal. So we know that an employee can bring a claim for unfair dismissal if the dismissal is harsh, unjust or unreasonable, or it's defined as a redundancy, but actually it's not genuine. Now, there are 3 factors that go towards the genuineness of a redundancy, if that's a word. Yeah, I just made one up there on behalf of ADP and Workforce Guardian. All right, so first of all, the position has to no longer be required, and that means effectively no longer required to be done in the same way. So you might have 2 full-time employees, but now you've realised you only need 1 to do a particular job because of changes in the business's circumstances. Or maybe you've got a part-time employee and you realise that actually you need a full-time employee. These are all legitimate reasons why the position might no longer be required. Of course, outsourcing is another classic example, along with automation. So a machine takes over what a person was doing before.
Mergers, acquisitions.
Yeah, happens all the time, especially in our economy now.
Yep.
Okay, the second is that all opportunities for redeployment have been fully considered. So if there's another vacancy within the business, really no matter what that vacancy is, the employee should be offered the opportunity to be redeployed before the redundancy is confirmed. And the third requirement is that all consultation and any other related obligations to do with the redundancy have been met in full. Now, if a modern award applies to your workplace, which it almost certainly will, at least somewhere, to at least one of your employees, then if you're making that employee redundant, you must comply with the very, very strict obligations that are imposed by that award. Every single award contains a clause relating to consultation in advance of a major change, and a redundancy is definitely a major change. So if you don't engage in that consultation process, you are opening the door for the employee to bring an unfair dismissal claim.
Yep.
Now, having said all of these things, making someone genuinely redundant is perfectly legitimate, but you have to make sure that you meet this genuineness requirements. And one other thing here is you cannot use the redundancy process anymore as a way of getting around any other dismissal process. Don't go down the path of saying, well, it's just too hard to dismiss this person for their misconduct. Instead, I'm just going to make their position redundant. Because if you haven't met all of these criteria, it will be an unfair dismissal anyway. And one last point here, Angela, make sure that you do these things before you confirm the redundancy. Now, there's a lot of great advice, support, and help that the Workforce Guardian from ADP team can provide. One of them is not time travel. So the number of times that people contact us and say, well, I've just done this, or I've just issued a letter of redundancy to my staff, can you tell us how much to pay them? And then we say, well, did you engage in these processes, these requirements beforehand? No, we missed that step. Well, unfortunately, it's too late.
Yeah.
We can certainly tell you what to pay out to them to make it a genuine redundancy in terms of the scale, the pay scale that has to be paid out under the National Employment Standards, but that's not going to make it a genuine redundancy.
Yep.
So it's going to result almost certainly in a claim being lodged, and that can be, as we've already discussed, time-consuming and very, very costly.
And David, I think what's really interesting about this is that the tax office actually has their own definition of a genuine redundancy, insofar as there is actually tax rulings issued about genuine redundancies, and it's similar. The theme is quite similar. It's amazing how many people do actually get it wrong, and you know the Tax Act actually goes as far as to say that if you later redeploy that employee, then it can't be a genuine redundancy for tax purposes. It talks about a number of different things. So it's actually it's quite interesting that there is one definition from the sort of Fair Work and HR perspective. There's another definition which is closely aligned but not quite the same for tax purposes. I won't be going into the definition of genuine redundancies for tax purposes today in my tax consideration section because we were going to go into genuine redundancies in a little bit more detail in the part two webinar. But just for tax enthusiasts out there, you might have, or am I the only one, you might have picked up on that whole genuine redundancy vibe that David was talking about and thought, oh, hang on a minute. So yes, there is a very similar terminology being used and very similar types of tests, but it is different.
Yeah, and that flows through to another example that we've discussed previously during our webinars. For example, the definition of independent contractor versus employee. And as we've discovered, the ATO has its own definition of who is an independent contractor, which is different from the definition that's used in the Fair Work Act and by the Fair Work Ombudsman. So just in case you didn't already have enough on your plate as an employer, bad news, two government agencies using similar terms but for completely different purposes. Very confusing.
And then to make it even worse, some of the state legislation on, say, payroll tax and stuff, contractor provisions in there could be totally different again. So
right. Well, let's move on before any of our listeners hang up and decide to go to the pub. All right. So bear with us. We have got some useful advice for you. Unfortunately, we also have to tell you the reality of operating a business in Australia, and as you've already discovered, no doubt, it can be very, very difficult. All right, so the next point that I'm just going to make here is we've been talking about unfair dismissals so far. There is one other type of dismissal that is sometimes confused with an unfair dismissal. So I just wanted to compare and contrast these two different dismissal types so that you can understand how they sit side by side. So remember, an unfair dismissal is harsh, unjust or unreasonable, or it's a non-genuine redundancy. But we sometimes hear the term unlawful termination or even sometimes unlawful dismissal. And in fact, a number of people use these terms interchangeably, and they really, really shouldn't, because these are two completely different concepts under the Fair Work Act. So unlike an unfair dismissal, an unlawful termination is where someone is fired for a reason which is expressly prohibited by the Act. So it doesn't matter if they were dismissed in circumstances which were very fair and very reasonable. If it was for any of these reasons, then it is automatically unlawful. So the Act says that if you were to dismiss someone because they chose to be involved in a union or chose, in fact, not to be involved in a union and there was pressure on them to do so, if you dismiss them for that, that would be unlawful termination. Similarly, if you fired someone because of what we call a protected personal attribute, so if you fire someone because of their age, their race, their gender, their religion, for example, they would all be forms of unlawful termination. Again, if you fire someone for what's called a temporary absence, and that is an absence unpaid of up to 3 months in any 12-month period. And it doesn't have to be consecutive. It could be lots of small breaks. Yep. So let's say you have a very sickly employee, takes lots of time off, has used up their personal carer's leave. If you were to dismiss them because of their absence, and you did that before they had been absent for at least 3 months in total in a 12-month period, that's also an unlawful termination. And it's worth noting that even after you get past that 3-month hurdle, you still have to meet other hurdles as well, or else you're going to face what's called an adverse action claim. So you can see here how important it is to get this advice before you proceed. Then if you were to dismiss someone because they happen to lodge a complaint against your business with, say, the Fair Work Ombudsman, or if they contacted the Fair Work Ombudsman to query their rate of pay or their employment status, their reward coverage, and then you fired them as a result, that's also an unlawful termination. And as you would expect, firing someone simply because they're choosing to take parental leave, whether they are already on it or they've just requested it, that is also an unlawful termination. So keep that concept very clearly compartmentalized in your mind, because an unlawful termination, it doesn't matter if it's fair, reasonable, lovely, no relevance. It is automatically unlawful, okay? So keep that in mind. We'll go back now just to unfair dismissal, as we were talking about before, now that we're clear about that distinction. So there are some people who in Australia are not covered by the unfair dismissal provisions. All right, the first of those are independent contractors. Now again, the Fair Work Act, as we just mentioned, has its own concept of an independent contractor. The Fair Work Ombudsman has its own decision tool and its own list of factors to determine if someone's an independent contractor. But a true, genuine independent contractor under employment law cannot generally bring an unfair dismissal claim. The second exclusion is if you've employed someone expressly on a fixed-term arrangement. So you could employ anyone, for example, covered by a modern award. They can all be offered fixed-term employment. That's perfectly fine. So you could employ someone in your business for exactly 3 months. So if at the end of that 3 months you're not going to keep them, they can be let go at the end of that time and not bring an unfair dismissal claim. They could be there for 5 years if it was a 5 years fixed-term contract. And at the end of that, you can let them go. They cannot bring a claim. However, the biggest mistake that employers make is to engage someone on a fixed-term basis and then allow the contract to sort of automatically roll over. So the contract expires on the 15th of May, but no one says anything, and on the 16th of May, the employee is still there and their work continues. Well, if you don't dismiss them at the end of that period, then they will become protected from unfair dismissal if they then have also completed the minimum employment period, which we'll talk about in a moment. Okay, and similarly with fixed-term employees, if you've employed someone for a 12-month fixed-term contract and you fired them at 11 months, well, depending on the size of the business, as we'll see in a second, they could have become protected from unfair dismissal, in fact, at the 6-month mark. And now you're dismissing them, even though they had a fixed-term contract, you're not dismissing them at the end of that contract. You're dismissing them early. And there have been lots of cases where an employee is dismissed early, and then the employer not only faces an unfair dismissal claim, but depending on the wording of the contract, is even then forced to pay out the remaining term of that contract.
Wow, that's tricky.
Yeah, very tricky. So again, it comes back to how important it is to get good advice when you hire someone, and that you make sure that you're generating fully compliant employment contracts. And lastly, we come to this concept, as we've already mentioned it a couple of times. Oh, in fact, I just skipped over one there, I noticed. Employees who are not covered by a modern award and who earn more than the high income threshold. That's a very important exclusion. So the current high income threshold is set at just around, it's about $136,000 a year. It's exclusive of compulsory super. So if an employee is guaranteed to earn more than the high income threshold each year, and if there is no modern award that otherwise applies to their position, then they are also excluded from protection from unfair dismissal. So they cannot bring a claim under the Fair Work Act for unfair dismissal against you. Now, the point that I was about to come to a moment ago was the minimum employment period. So really critical to note that we have this concept in Australia of a minimum employment period. And until an employee in your business has completed the minimum employment period, they are not protected from unfair dismissal. So what is the applicable minimum employment period? Well, the good news is it's a relatively straightforward test because it's based on a simple head count. And if you have fewer than 15 employees, remember, under the current laws, that means that your business is a quote-unquote small business. That means that the minimum employment period is 12 months. And in a business with 15 or more employees, the minimum employment period is halved to 6 months. So the idea is, so did I say 6 months twice then? I say 12 months before.
No.
Yeah. Oh, good. So fewer than 15 employees, 12 months, 15 or more employees, 6 months. Now that head count that we've just discussed, it's a simple head count. There are some exclusions, for example, sporadically employed casuals, all right, but long-term regular casuals would need to be included. And the other group that need to be included are any employees in what are called associated entities. Now, I did 5 years of law school, and I don't wish that on anyone, so I am not going to launch into a legal lecture about the meaning of associated entities. Suffice to say that Section 50 AAA of the Corporations Act contains the definition of associated entities. And what we're talking about here is really where there's a connection between one business and another. So, for example, they might have the same owners or the same directors, same shareholders. One might have a controlling interest in the other. There's a whole range of different ways that they could be linked. If they are, then when you do that head count, you actually have to count all of the employees in total, not just the ones in the specific business where the employee that you're thinking about firing works. So you have to add them all together. And again, if you then come to 15 or more, the minimum employment period is only 6 months. Okay? So critical to note this distinction, and really those 6 or 12-month periods, if you like, they are the default probationary periods, because the Fair Work Act, what does it say about probationary periods? It says absolutely nothing, because the Fair Work Act doesn't recognise them at all.
They don't exist.
They don't exist under the Fair Work Act. All that exists are the 6 and 12-month minimum employment periods.
And the associated entities, for those playing along at home, you have to look at the same tests when you're grouping for payroll tax purposes and for other tax obligations as well. So maybe it is time to get familiar with some of those conditions and tests, I think.
Wow, are you saying, Angela, that the same test is used by 2 government agencies?
Yep.
Wow, that's amazing.
They both refer back to corporations.
Oh, right, we've got one underpinning.
Yeah.
Oh, you just gave me some hope there for a minute that our government departments were speaking to each other. But never mind. All right, at least we've got the Corporations Act being consistent. That's good. Okay, so now that you know who is and is not protected from unfair dismissal, and if you've decided to go ahead with the dismissal, here's our handy step-by-step guide to reduce the chances of a claim being made against you. So step 1, carefully consider and document for yourself the reason for the proposed dismissal. So the key question you're really asking yourself here is, will the dismissal be lawful? Remember, not unfair, but lawful. So if when you consider and then document the reason for the dismissal, you discover it's because the employee made a complaint about you, or because you don't like the fact that the employee is involved in the local union, well, there's a big problem, because your dismissal is going to be unlawful, all right, straight off. So make sure you carefully figure out why it is that you're letting them go. Now, if it's to do with performance or it's to do with misconduct, well, they would be legitimate reasons to dismiss someone potentially, all right? But before we even get there, I want you to consider their conduct in relation to your policies, procedures, and even your previous practice, because consistency is important. So the question you're asking yourself here is, will the dismissal be appropriate in the circumstances? So if someone's been with you for 10 years and they're late once to work and it really makes you angry, would it be appropriate to dismiss them for that? And the answer, I think, from any reasonable person is no. All right? So whereas if you've got someone who's been with you for 3 months and they've been late 20 times, that's a different story. Okay? And also good to know if they've only been with you for 3 months, they're not yet protected from unfair dismissal anyway. Okay? So step 3, carefully consider all of the different things, all of the possible outcomes and consequences of letting them go. So before you do anything, and again, this is just like we discussed before with time travel, before you confirm to the employee that you're planning to dismiss them, spend some time to think about what other possible claims that could be made. And in so doing, think about what you can do to minimize any risks. So if you know that there's a potential of a particular type of claim being made, perhaps unfair dismissal, what can you do to reduce those risks before you confirm the dismissal with the employee?
I'd call you, David.
Thank you for that. That wasn't even a pre-planted response, but thank you very much. Yeah. And of course, if you are an ADP client, you can phone the ADP Workplace Information Service, which is run by Workforce Guardian, and our team will gladly give you that advice. All right, so you get to step 4 now. Now, you've decided to proceed with dismissal. Make sure you confirm a proper process. So sit down and work out this process before you get into it. The first thing to note here is don't ever fire someone in the heat of the moment, all right? Bad move. And sometimes in the heat of the moment is because there's an argument going on. Never a good time to then let someone go because you will almost certainly face some kind of claim as a result. Second, and look, I don't think I really need to say this to employers, but it does come up often from the other side. Don't dismiss by text message or by Facebook post, because not only is it really bad form to dismiss someone by text message or Facebook post, you will end up on a current affair. Or
that actually happens.
It did.
Dock workers get dismissed by text message.
And it was on a current affair.
Yeah.
So it will happen, right? Like you'll get very bad publicity because all of a sudden your brand is ruined because you become known as that business that just doesn't care and does things like that. So apart from the fact that it is a very, very poor form of communication, it just is damaging to your reputation. So don't ever dismiss by text message or Facebook. Now, again, you should also check if a final warning has been previously issued. So if the employee has finished the minimum employment period and if they're not a casual, then make sure, unless they've engaged in serious misconduct, that you have given at least one final warning in the past.
Yep.
If not, it's almost certainly going to be an unfair dismissal. And again, remember that before you dismiss someone, even in cases of serious misconduct, you must give them an opportunity to respond before you confirm your decision. Now, you don't have to do that in person. You can send a letter to them, send them home for 1 day on full pay, what we call standing down. As long as it's on full pay, that's perfectly fine. And you can say, I want you to come back with your response before close of business tomorrow, and we'll consider that and then confirm our final decision. That's perfectly fine. And document every step that you take. Now, when we say document, apart from the written communications between you and the employee, actually I also recommend you write emails to yourself. Now, I know that sounds a bit crazy, all right, but bear with me here, all right, stay with me. What I'm talking about is sending yourself an email summarizing what steps you've taken and why you've taken them. And then once it arrives into your inbox, click and drag it into a folder that you've set up specifically relating to this matter. And the reason I want you to do this is because when you send an email to yourself, it is time and date stamped. It is guaranteed proof of the process that you went through and your frame of mind at the time. And if a claim is lodged against you, it's very handy in the commission to be able to produce evidence that at the time of the dismissal, you were carefully considering your obligations, documenting the steps you were taking, and trying to do everything absolutely right. So, good idea.
Sounded crazy to begin with.
Yeah, it did, I know.
But now it makes sense.
Now it makes sense, yeah. People are saying, you think these Workforce Guardian people, they just email themselves all the time. How odd. All right. Now we get to step 5. If you've gone ahead and dismissed, make sure you provide the applicable notice period. If you're dismissing someone who's a casual or because they've engaged in serious misconduct, you don't have to give any notice. If they're a permanent employee, though, remember that you do have to give notice, even if they're still within that first 6 or 12-month period of employment. So less than 1 year of service, they need 1 week's notice. 1 to 3 years, they get 2 weeks, and it goes on. One important point to note, if the employee is over 45 and they've also worked at the business for at least 2 years at the time of dismissal, they're entitled to 1 extra week of notice. So if we look at that second table there, 1 to 3 years, if the employee was in that 2 to 3 year bracket and they were over 45, they'd be entitled to 3 weeks. and so on.
It's interesting though, isn't it, David? Because most employment contracts give you like 4 weeks notice, don't they?
They do, and that's a far more generous entitlement than you can see is imposed by the National Employment Standards, which come from the Fair Work Act. Our recommendation is you actually stick with the NES, stick with the National Employment Standards, unless there is some very good reason why you're providing a more generous entitlement.
Yep.
Okay? And step 6, provide all the final entitlements to the employee. So remember, any unused annual leave always needs to be paid out, and unless you're offsetting it, and the offsetting is expressly permitted by law, and in a lot of cases the offsetting is not, so make sure you double check that, and remember that unused annual leave generally needs to be paid out in full. If the employee would have been entitled to receive annual leave loading, if they had taken the annual leave, then it must be added onto the payout as well. Make sure you pay out those final wages and salary payments in your next normal pay run after the date of dismissal. Remember, don't take unlawful deductions out of the final pay, and that's what I was getting to just a moment ago. A lot of employers say, oh, well, they didn't return the company mobile phone, so we'll just take out $200 from the final pay. That's nice. You cannot do it. All right? Simple as that. Unless it's in an enterprise agreement or a modern award, you cannot do it. Even if it's in the contract of employment, you cannot do it because the legislation, the Fair Work Act, overrides your contract. And remember, as an employer, there is no obligation to issue a reference to an employee at all. You absolutely do not have to give a reference. The only thing that you can be required by law to provide is a document called a separation certificate, which is published by the by Centrelink. The employee can request that, and then in which case you have to fill it out and submit it back to the employee. Okay, so now you've gone through the whole dismissal process. I just want to touch on this concept of deeds of release. Deeds of release are kind of like a no-fault divorce. So it's a way of ending the employment relationship whenever there are any contentious matters and drawing a line under it. So let's say you've dismissed someone, they feel very aggrieved about things, they haven't necessarily lodged an unfair dismissal claim against you, but you're obviously in back and forth dialogue, maybe there's a dispute about something and they're making threats about legal action. Well, you could draw up a deed of release, sometimes called a deed of settlement. This would set out the terms of the employment ending. Normally what it involves is the employer making some goodwill payment to the employee. In return, the employee waives their right to take any further legal action. So it's a nice way to draw a line under the whole scenario, make sure that everyone's got complete peace of mind that it's done and dusted and everyone can move on. So deeds of release can be particularly useful in a termination scenario, and indeed they are routinely used by the Fair Work Commission whenever an unfair dismissal case is settled. The Fair Work Commission actually has its own template deed of release. Okay, so very common to see these around. Okay, and lastly, what do you do if a claim is lodged against you? So you've done all the right things, you followed all of our advice today, but still someone lodges an unfair dismissal claim against you. Well, not surprisingly, the first thing I'm going to say is get expert advice before you do anything. One of the worst mistakes you can make is to start engage in the process without knowing what your rights and responsibilities are. Yeah. Secondly, make sure that you check that the applicant, that is the former employee, is actually eligible to bring an unfair dismissal claim. Because remember, if they haven't met that 6 or 12-month minimum employment period, for example, they are technically not entitled to bring the claim in the first place, in which case there is a process that you should go through to get the case thrown out. The employee's application for unfair dismissal is what's on a Form F, it's called a Form F2. Your response is on a Form F3. So that'll be sent to you by the Fair Work Commission, complete it with some help and send it back. You'll then be asked to take part in telephone-based conciliation, and at that point you can do that and then consider settlement. The correspondence from the Fair Work Commission implies that you must take part in conciliation. You absolutely don't. You can refuse to take part, that's perfectly fine, in which case the matter automatically goes to arbitration, and at arbitration that's at the Fair Work Commission, and that's where you'd be asked to actually formally present the case. So that is, from an employment law perspective, the full cycle, if you like, of unfair dismissal. Yep. And given that, I'm now going to hand back to you, Angela, and you can take us through the tax considerations of these final payments.
Okay, everyone. So if you weren't already asleep, I'm hoping not to be because I know this is David's favourite. Every time he hands over to me, it's done with a roll of the eyes. So duly noted, David. Thank you very much.
I secretly love that.
So what most people would know termination payments as is an ETP. So employment termination payment is the official term given to the payment type when someone is either terminated from employment or is terminated due to death. So Either way, it is still classified as an ETP. So I wanted to go through what's actually included in an ETP because it's so often that I get people trying to bundle things into an ETP that don't belong there. So I would like to discuss that in just a little bit of detail. So payments in lieu of notice are included, a gratuity or sometimes as they're known, a golden handshake. Compensation for wrongful dismissal is also included. Now, I've got a note there, that's the little asterisk, that it has to actually have been paid within 12 months of the actual dismissal taking place for it to be treated as an ETP for tax purposes. So that's my little disclaimer.
Some conditions apply.
Some conditions do apply, correct. Apply within. And then payments in respect of a genuine redundancy or an early retirement scheme that exceeds the tax-free limit. So that last one, genuine redundancies and early retirement schemes have a tax-free component, which I'll go into a little bit later on. If you've paid over and above that amount, then that additional amount over and above that tax-free limit goes into the ETP calculation. So that said, what's specifically excluded from a termination payment? So this is, as I said, where I think some people needed a little bit of clarity. Unused annual leave, and when I say annual leave, including the loading that might be applicable, and or long service leave balances upon termination are not part of the ETP.
Okay.
They must be taxed separately, and I think we've probably covered that off in one of the earlier webinars anyway, but they are specifically not part of the ETP, so please don't bundle them in with the other part of the ETP. Wages, salary, allowances, bonuses, and anything else owing to the employee for work already performed or for leave already taken should not be included in the ETP. Okay. So if you're doing the final pay, you don't bundle it into the ETP.
Right.
Yep. Payment for a restraint of trade, employee share scheme payments. Oh, I dare you to say that one 5 times fast.
No.
And foreign termination payments. So the big one is the leave, but I just wanted to make it clear that they shouldn't be put into the ETP calculation and treated conditionally, which is what ETPs are.
Right, okay. So if you were to put them in, that would be effectively breaking the legislation, because you'd be giving favourable tax treatment to something which falls outside.
Correct, yep. Now that said, I mean, unused leave balances does have concessionary treatment in itself, if that's a word, concessional treatment in itself.
Okay.
But again, it does not belong in the ETP, so they're totally different. So what I wanted to touch on is there's a few components and considerations when you're trying to work out what your total ETP for an employee is. First and foremost, I wanted to point out the 12-month rule, which basically says if you don't pay the ETP within 12 months of the termination of the employment, then it doesn't qualify for any of the ETP treatment. Okay, so it would just be treated as normal taxable income for the employee and taxed at the normal withholding rate tables. So that's the first thing. It must be paid within 12 months, otherwise none of the rules, none of the concessions and none of the tax treatment I'm telling you now is going to apply.
Right, okay.
Good one. So the next one is the age of the employee. Now obviously through your payroll you'll have a lot of these details, but I'm just making it clear to you that you need to calculate the preservation age of your employee at the time of termination. So preservation age it's an age that's determined by the ATO. There's actual legislation that determines what a preservation age is. It's based on the date of birth of the employee. So I'll give you an example. There is a table you can look up, but as an example, if your employee was born between the 1st of July 1960 and the 30th of June 1961, the ATO deems their preservation age to be 56. So whether the employee is at their preservation age or not at the time of termination, so in this example 56 years of age, will determine what tax rate you're actually going to apply later on.
Okay.
Yeah.
I never knew that.
Yep.
Yeah, I learned something new
today.
You did. About tax.
About tax. So the age is very important, so please don't forget that. And then I wanted to talk about components. So there's components of an ETP. There's a tax-free component. That could be an invalidity segment, which is obviously where termination is due to the employee physically being able to not perform their duties anymore. Then there's the pre-July 1983 segment. So if the employee has been with you for a very, very, very long time and has had service with you since before July 1983, that part of their service is deemed to be tax-free.
Wow.
Yeah. And then obviously we did talk about genuine redundancies and early retirement schemes which have that specific tax-free limit. So that currently is at $9,780 lump sum plus $4,891 per year of completed service, so not including part years.
You just knew that, didn't you?
Yeah, totally.
That was pretty impressive.
So yes, and just a side note, early retirement schemes that I've mentioned twice now, they actually have to be approved by the ATO. So it's not something I can define for you. It's something you have to apply for and get some approval for.
You can't just make up your own.
Absolutely. Okay. And lastly, the really important part. Oh, sorry, I need to jump back a bit. I'm doing what you've been doing today. In the components, the other component is the taxable component of the ETP, obviously, and that is a very complicated definition. It is whatever is left over after the tax-free has been taken out.
Okay.
So very high-level technical definition. The last consideration on insofar as ETPs go is the reason for termination. So we've already discussed they have to document their reason and rationale for HR and employment law purposes. Mm-hmm. And I guess this is an extension of that. You need to know why you're terminating them to know how it's going to be treated for tax purposes. So as we'll see as I go on, there will be a slightly different treatment depending on what the rationale behind the termination was. So just bearing that in mind. Okay, so how do you tax it? So we talk about life and death benefit ETPs insofar as there is a different treatment whether you are paying it to an employee who's just terminating employment or to an employee who has died and you're paying it to either a dependent or a non-dependent or the deceased estate. All of those play a part.
Wow.
Yep. So who's receiving it? Who's getting this ETP? And each of those has a different sort of tax attached to it or level of tax. And then what I think a lot of people get confused about is there's actually two caps. So caps are ETP cap or whole of income cap. Now what does cap mean? Cap means that up to one of the caps you will actually get the discounted tax treatment or concessional tax treatment. Any ETP over and above the cap generally gets hit at the top marginal tax bracket, tax rate. So it's important to know that caps exist and which cap should be used when. So the whole of income cap is very specific. It only applies to non-excluded ETPs, which means things like golden handshakes, gratuities, and payments that don't meet the definition of genuine redundancy. A lot of the time what will happen is you have to work out which is the cap that works out to be the less. So ETP cap is a set amount by the ATO. Whole of income cap says it's $180,000 a year, less any other taxable income that employee has had for the year. Right. So if I've had $50,000 worth of wages paid to me in that year already, I have to take the $50,000 off my $180,000 cap.
And then you'd be buying lunch.
So it's really important to differentiate. There are two different types of caps and they do apply to different types of terminations. So to tie it all in together, where do we look? Schedule 11. So you'll be familiar if you've been following these webinars that I do refer to schedule numbers quite often. Schedule 11 is the tax table for employment termination payments. It's beautiful, I must say. I'm showing it to David for those of you playing on the phone. It's really detailed. It does differentiate in the first column between a life benefit ETP and a death benefit ETP. Then it breaks it down to whether the employee was under preservation age, over preservation age, or in some cases regardless of age. And then it even tries to steer you in the direction to say this is the cap that you need to apply to that type of ETP. And lastly, it gives you the withholding rate that you should apply. So it sounds terrible, but the table is quite digestible, I think. Well, I really wish we started taping some of these webinars because David's face is classic, but I think it's quite digestible. So Schedule 11 is where you need to go. Once you have all the information, you've worked out your various components, the preservation age of the employee, it's the place to go to complete your calculation for tax purposes. Lastly, it wouldn't be as simple as that. We have to report. So I think this is another area where I've seen a lot of employers get it wrong, especially when I've talked to clients now. There is a separate ADP payment summary, which I've listed there, NAT 70868, which is the payment summary that you actually issue to employees who have terminated and received an ETP. It's only required if you have an ETP that requires tax to be paid, so to be withheld. So if it's completely a tax-free genuine redundancy, then you don't have to issue one.
Okay.
But here is the clincher. It has to be issued to the employee or the deceased estate within 14 days of the payment being made. So it doesn't actually give you a very large window to have that done. So please remember that that is a separate payment summary to what you'd ordinarily issue at the end of the financial year. They're both called PAYG payment summaries. However, the NAT 70868 is specifically the one for ETPs. From an employer perspective, reporting to the ATO, you still include it on the PAYG payment summary statement that you lodge at the end of the year, so that doesn't change as an employer. Okay. It's only the employees that actually receive something separate. And then I've left a note there for you to say if it is completely tax-free, then you don't have to issue the separate ETP payment summary to the employee. You can disclose it at lump sum D, which is a box on the ordinary pay-as-you-go payment summary that you issue at the end of financial year. So just some really key notes to take away from that, I think.
Yep. Okay.
There's always reporting requirements, David.
Yeah, and exclusions and inclusions.
That's right.
That's the same in the Fair Work Act, so yeah.
So obviously we've shared a lot of information here today, and we've already demonstrated how confusing this all could be. So we really hope that we've armed you with some knowledge, or at least knowing where to look to find some knowledge about this extremely complicated topic. If you are interested in learning some more, or if you just really love the topic, we do encourage you to give us a call. So if you are not a client of ADP, please feel free to call us on 1800 000 729. For good news for our clients, you have access to the ADP Workplace Advice Line powered by Workforce Guardian, David's team, and you can call us on 1300 443 088 to seek some helpful advice from David's team. David, thank you very much for being here today.
Thank you very much for having me. It's been a pleasure. I know these two topics that are very, very difficult for employers, and I think we've just tried to inject a little bit of, plain English and a bit of humour into what are two very, very difficult subjects. But I think it was really useful information for sure.
Thanks, David, and we really appreciate having you here today.
Pleasure. Bye now.
Bye, everyone.